I just wanted to first of all say thank you for anyone that is new to our series. My name is Stephanie Morris. I'm with the Refugee Alliance of Central Iowa. Also from Rossi today, we have Valerie Bouvat de Virginie, who is the Rossi AmeriCorps Vista. And Valerie is actually going to be facilitating questions at the end. And I will stop talking and let you guys actually hear from the first off. So today we wanted to, one of the biggest asks or responses that we received from our refugee communities was to be able to get information and share it specific to tenant rights, especially with all of the different housing insecurity issues going on currently. So Ericka Peterson is actually joining us today. She's currently the Assistant Litigation Director at Iowa Legal Aid. She rejoined Iowa Legal Aid after spending 2 years teaching at Georgetown in the Health Justice Alliance Law Clinic. Earlier this year, she published an article in the Journal of Civil Rights and Liberties called Building a House for Gideon, the Right to Counsel in Evictions. And prior to teaching at Georgetown, she was a staff attorney in the Cedar Rapids Regional Office of ILA, or Iowa Legal Aid, representing clients in a variety of civil legal matters, including eviction and subsidized housing termination defense. So as you can see, when it comes to issues of tenant rights and evictions and what's going on currently as people are navigating the housing crisis that's happened after COVID, she is definitely the person that we would love to hear from. So I will be quiet and let the expert share information.
Well, thank you, and thank you for having me. I also just want to say that I have allergies and also think I'm getting more out of shape due to COVID and might get shorter sounding of breath than I should be for giving a presentation, so I'm sorry. I'm going to go ahead and try. I have a PowerPoint for you today, so let me see if I can get that shared with you without problems. Oh, it says the host has disabled participant screen share.
Let me do that really quick for you.
Thank you.
Okay, you should be all good.
Okay. Okay, can you see my screen okay?
Yep, perfect, thanks.
Cool. All right. Come on there, buddy. Okay. I'm gonna try and get rid of you guys, but if you have a question, just, just let me know, or do a comment too. I can try and pay attention up here. Okay, so yes, I'm Ericka Peterson. I'm the Assistant Litigation Director at Iowa Legal Aid. For those of you that aren't familiar with Iowa Legal Aid or don't know as much as you could know, a little bit of information about us. We are a civil legal aid society, meaning we represent low-income, elderly, and other vulnerable Iowans in a variety of civil legal matters, and we are a nonprofit. The issues we represent in or assist with include housing, family law, employment, healthcare, government benefits, disability benefits, consumer debt, and collateral consequences like expungement and court debt. Our really big bread and butter is housing and especially evictions, and those are up substantially right now. We're seeing just huge increases over last year, sort of unsurprisingly, and the number of people calling us for housing related and especially eviction issues. And we also, the family law that we practice is for victims of domestic violence. So that includes protective orders, custody, and divorce cases. A couple of things that are maybe relevant to the work you do is that you can call our 1-800 number for an application. You can also do one online. We have interpretation available in many languages. And there was one other thing. 2019, we closed just under 16,000 cases, and we have offices in 10 cities across the state, covering all 99 counties in Iowa. So that is a little bit about us and our contact information. What I'm hoping to cover today is, one, some of the basics, important things to know about entering a tenancy in the first place. the rights and obligations of a tenant once they've entered that tenancy, what to do if repairs are needed, which is a big issue, what the eviction process looks like and what tenant protections exist in that process. A major one of those protections right now is something many of you probably have heard of by now, is the CDC eviction moratorium. And then finally, a bit about rent assistance and some of the legal barriers that may be in place, maybe preventing tenants from paying rent. So to get us started, and I'm kind of bummed because I went back and forth thinking maybe I should do like a pop quiz, because that's how we often do our tenant things, our tenant presentations live. And they're usually kind of fun, but I didn't know how many people would be here, so I went with the boring route of just a PowerPoint. I'm sorry. But these are some sort of important things to know when you're thinking about entering into a tenancy in the beginning. One is that a deposit can be no more than twice the amount of monthly rent. A rental agreement does not need to be in writing. A lot of people think that, oh, I don't have a lease because it's not written down. The simple fact that you are paying rent and being allowed to live there, that actually creates a contract in the eyes of the law. And so you do have a lease, and that with that lease, you have certain rights, even if it's not written down. Of course, it is better to have it in writing because all sorts of problems can arise when you don't have it in writing, and two parties can remember a conversation differently, even if there's no intent to do so. So writing is always best. Something that comes up frequently that we see a lot, I guess, is a landlord cannot refuse to rent to a tenant because they have children. For a lot of other reasons too, as I've listed here, but children comes up with more frequency, and I think people think that that's actually maybe legal, and it's not. It can also come up in different ways without it being explicit. Things like a person facing eviction because they're too noisy, and if they have kids, there's a reasonable amount of noise that just has to be expected. God knows I have a 2- and 4-year-old, so and actually we were renting in DC over a person, so kids can make a lot of noise, and we all know that, and that just is part of it in a rental situation. You can't deny someone for that. Another way we see that is increasing deposits for children, which is also not acceptable. And then, of course, you also cannot discriminate against someone because of their race, color, national origin, religion, sex, sexual orientation, or gender identity in Iowa. Another important thing is that in the cities of Des Moines, Iowa City, and Marion, a landlord cannot discriminate based on the method of payment. So the common way that this is going to come up and sort of how this law developed was because of Section 8. Section 8, of course, one of the ideas behind it was to unconcentrate poverty and deconcentrate poverty, perhaps is the better word. But in any case, that didn't work so well because landlords could say, well, I don't take Section 8, which is usually, let's be frank, a guise for discrimination of some sort. So a lot of cities have started passing what we call source of income discrimination ordinances. In Iowa, there's 3 cities that have it, and they can't. Landlords actually can't not accept rent assistance. That's also become increasingly important right now when a lot of people are relying on rent assistance because of the pandemic. And something I hear from providers quite often is, well, what about if they tell me that they just don't feel like sharing their bank account, or if they don't accept checks or put up other small barriers? And my position, for what it's worth, is that that is not okay. These are new laws in Iowa, and in fact, the state considered passing a law that you couldn't have these sorts of ordinances. It did not ultimately pass, so we'll see what happens in the coming year. But if you look at the national landscape, a lot of courts have ruled that putting up barriers like I don't want an inspection or I don't want to give out my bank account is not acceptable, and not a reason that you have to go along with the inspection if a Section 8 tenant comes to you, etc. Okay. Having trouble getting my slide to move here. Another important thing when a tenant is moving in is really truly doing that walkthrough. I think a lot of people are aware of it, but when you enter a relationship like a landlord-tenant one, you had a great conversation, the landlord seems nice, you're excited, and you think, what's gonna go wrong? And of course, my view is quite jaded because people come to me when the thing has gone wrong. But when it goes wrong, it can go really wrong. And there's some really simple, important steps to take. So either do a walkthrough with your landlord and note things that are wrong at that time, or often many landlords will provide that checklist that I'm sure many of us have seen. Actually do that, actually fill it out, and then either get that checklist or a letter that says, we walked through on this day and these are the things that were dirty, broken, or in poor condition, and give it to your landlord or have the tenant give it to their landlord and keep a copy too, because that actually may be important when a landlord tries to keep the deposit, which happens all too often. Another thing to do to protect yourself is to take photos or video of the unit before the tenant moves in, showing any damage. Okay, so once the tenant has moved in, there are duties that the landlord has and there's duties that the tenant has. So some of the landlord duties are following building and housing codes. This is it can be kind of difficult because it's city by city on what exactly their ordinances are, but we know the basics, right? Like no infestations, no rats, no bats, no bugs, doors have to work, windows have to exist, these sorts of things. You're gonna find those in every building and housing code across the country. I'm sorry, across the state. Sorry, I just saw a chat here. Yes, definitely can get you a copy of this presentation. Other things that the landlord has to do is make necessary repairs. This is something when I practiced in Cedar Rapids, I think all tenants are potentially susceptible to the bad acts of a landlord, but particularly immigrant populations really got taken advantage in this area. In part, it would be, I think, immigrant populations, but really all tenants don't necessarily have a good grasp on what their rights are on the maintenance of a house. All the time I will talk to a tenant asking well, are there problems with it? And only when you start pushing can you find out oh, that's a really serious problem. What? Your entire wall has mold? You've been living with mice for 2 years? Or one that I hear way too often is you don't have proper heat and you use your oven to heat the house. Those are all things that are not acceptable and the law requires the landlord to take care of. So I think immigrant populations, I've seen particularly vulnerabilities, but the real vulnerability I've seen is then taking advantage and trying to have those populations pay for the repairs. Landlords have to pay for those repairs unless the tenant intentionally caused the damage or maybe sort of recklessly caused the damage. If you were swinging a baseball bat around the house and then it went through the window, that's probably on the tenant. But even if in that scenario, if the tenant gets mad and bashes out a window and then it's November in Iowa and they don't have a window, the landlord has to fix it. They can then go charge the tenant, but they have to fix it. That is on the landlord. And that's really important that people know and understand that, because landlords all the time will do things like, well, you did it, so you have to pay for it. Other things that the landlord needs to do is be in charge of garbage removal, making sure to supply hot and cold running water, keeping all common areas, if it's an apartment complex, clean, and keeping all facilities like plumbing, appliances, heat, all in working order. On the tenant side of things, oops, I have to use my buttons. On the tenant side of things, tenants too have to follow building and housing codes. Then this is something I think probably you see at a higher rate in some immigrant populations too, of just different cultural standards, in particularly putting the oven on, leaving doors open while the oven is on. There's certain things that tenants are required to follow those as well. Cleaning your own living area, of course, proper garbage disposal, proper use of the appliances. So this is, again, can be a tricky one when you're using your oven for heat because you don't have any. It's going to be rare, but in theory, you could actually get in trouble for that. No damage to the apartment and no disturbance of neighbors. So on the no damage to the apartment front, the standard there is other than, oh my God, it's like a really common thing and my mind just went blank. But the standard is other than, sorry, normal wear and tear. That's what I was missing. And that means, you know, if you've got cheapo carpet in there and you've been living there for 3 years and it needs to be replaced, that's not on the tenant. If it's because of excessive force or using a door or two, whatever, it's something that the tenant really caused and shouldn't have been caused, that will be on the tenant. And then no disturbance of neighbors. This is a really tricky one because especially in situations, maybe a kid, like I mentioned before, or a child with a disability. I had a client once whose child had autism and had really intense sleeping issues. And she was in trouble for disturbing neighbors because the child would be awake at all hours of the night. There are definitely protections in place for people if they were to receive a notice for those sorts of disturbances. And that would be a situation that I would recommend talking to a lawyer about. Okay. So what to do when there are repairs needed? One of the most important things to protect a tenant is to make sure that the repair is requested in writing. That can be in text or email, or it can be an actual letter, but you want to then keep a copy. And if you do text or email, make sure you screenshot it or save it in some way so that you have a copy of it later. I'm going to answer this question here. Thank you. Good. And then another thing is allow for a reasonable time period to make the repair and allow access to the house. Those are sort of common sense, but that reasonable time period is based on the circumstances. If it's January in Iowa and your heat is out, that reasonable time period is probably a matter of hours in most circumstances. If an interior door is broken, you've probably potentially weeks. You know, it takes a while to order a door, etc. But you have to it has to be reasonable. A really important thing is to not withhold rent. A lot of people do this, and a lot of people understandably do it, right? I'm living in these horrible conditions. They're not doing anything about it. They don't get rent anymore. The problem is Iowa law actually does allow tenants to withhold rent, but in order to do so, they have to follow very strict rules in a very set way. And most people mess it up at some point along the way. And then they put themselves at risk of eviction. So generally speaking, it's not a good idea to withhold rent. The only time the law allows you to withhold all of your rent is when there's very serious violations, like basics like heat or water are not running. Most of the time, the only thing you can do is withhold after you've paid for a service. So, you know, my toilet won't stop running and my landlord won't come out, so I paid a plumber to come take care of it. Technically, you can withhold that, but again, you have to go through very specific steps to do that and give your landlord notice. And I'm sorry, I'm going to keep saying your landlord. I know you guys are not necessarily the tenants I'm talking to, but it's just so ingrained in me. Generally speaking, don't withhold rent. Get the advice of an attorney first. That's going to be the safer thing, because what a pity to have the rent money, not pay the rent because you're mad and then get evicted. And there's potentially other ways to get those repairs done. So one of those ways is maybe calling a housing inspector. Larger cities in Iowa are going to have housing inspectors. Some rural areas will not. If the housing is subsidized, meaning if it's a Section 8 voucher, public housing, project-based Section 8, USDA housing, all of those are connected to HUD, of course, or USDA, and they'll have inspectors available through those federal agencies that can also be very helpful. I once had a situation where a tenant was just not getting repairs over and over and over again. It was a heat issue, and she was paying out the wazoo because the heat would never turn off. And her daughter's room was so hot, she had to leave the window open, and it was this crazy scenario, and the landlord wouldn't act. And finally, the housing authority stepped in and just stopped paying the landlord's rent. And you can't, in most situations, this is one where you'd probably want to speak to an attorney, but in most situations, you can't get evicted if the housing agency stops paying. And so that's a really good way to get the landlord to do what they're supposed to. The risks of calling a housing inspector, though, are important. And the big one is if it's a very serious problem, talking like serious mold, serious water damage, sewage, serious structural issue, the risk the tenant may face is that a housing inspector will come out and what we call tag the house, saying this isn't actually fit for human occupancy. And so even though through no fault of their own, the tenant could end up being out on the street very, very quickly. And so that's a really difficult situation. As an attorney, I definitely let my client make the call on what they want to do in that scenario, but just know that that is a risk if you've got a very serious violation. But if it's a less serious one, the housing inspector can be very, very useful, and in some cities really will fine a landlord for not fixing anything in disrepair. It is also possible to terminate the lease. Sometimes a tenant just says, you know what, I've had it, I want out. It is possible to do that, you know, get your deposit back, not hurt your credit, but it can be tricky because, again, you have to follow very specific steps. And I'm always very wary of it because it basically terminates after a 7-day notice to the landlord. And more often than not, tenants don't have a place lined up in 7 days and then end up staying, and then the landlord can evict because the tenancy has been terminated by the tenant. So possible, but tricky and risky, and definitely a time where you might want to get a lawyer involved. Something important to know is that it is illegal to evict a tenant for requesting repairs. And that goes back to this putting it in writing. It's called retaliation. And if you can prove that you requested repairs in an eviction hearing, and then the landlord attempted to evict, unless it's about non-payment of rent, then I'm sorry, you all probably also hear my dog and child screaming. I swear my husband is up there with him, but again, he's 2. And hopefully my husband will get the dog under control, but I think we have a delivery. Anyway, it's really important to put it in writing because that's how you're going to prove to the court that it really happened. Really, that's the reason the landlord is trying to evict. I'm going to pause and give it a second just for any questions that might be out there. Okay. This one is the bundle of sticks is a law school thing, but I think it's a helpful thing to sort of understand. When a landlord decides to rent out their property, they've got sort of what you can imagine as a bundle of sticks related to their property. And when they rent, they're really giving up one of those sticks, and that stick is the possession of the property. A lot of landlords don't treat it that way. They act as if this is my property, like, and I can do whatever I want because it is my property. And it's really important for tenants to understand, no, yes, it is their property, they own it, but you have been given a stick in that bundle that can only be taken away by a court order. And until court orders that you don't have that stick anymore, you've got it and you've got rights that come with it. A big one that we see get violated a lot is that the landlord cannot just come in to your unit whenever they want. I feel like doing an inspection. I don't trust that you're up to this or that. Sometimes it's just a complete tool for harassment. Other times it's a landlord that maybe has a legit purpose, but walks in on I've had the case where he walks in on a 13-year-old girl who was getting dressed while her mom wasn't home. Not okay. Just because he has a set of keys doesn't mean he gets to use them. a landlord, he or she, can come in during an emergency though. So if you've got like a sewage backup or a bathtub that's flooding into another unit, those are the types of emergencies where a landlord is allowed to come in. But in most cases, they're required to give at least 24 hours notice to the tenant. And they have to work with the tenant, you know, hey, could you not come at 4? My kids are home alone during that time. Baby sleeps at 10, if you could come at 11. Those things are things that tenants or that landlords need to respect and be reasonable about. And on the flip side, tenants shouldn't be unreasonably withholding access. And like I said before, the tenant has a right to possess unless and until a court orders otherwise. Self-help eviction in Iowa is illegal. That means without a court order, a landlord cannot evict. They cannot take a tenant's things out of the home. They can't change the locks. They cannot evict without a court order. This also includes something that comes up more than you might think, which is constructive eviction. So that's things like turning off the heat or electricity, turning off the water, which makes a place that you're paying for either very uncomfortable or completely unusable as a house. And that basically what we call that constructive eviction. I once had a tenant whose landlord removed all of the windows and doors in November because, well, there was some sexual harassment involved, but also because she did not pay full rent that month. Those things are illegal, and a tenant can be entitled to quite serious amount of damages. In the case I was just referring to, the landlord actually got a day in jail and my tenant got substantial amount of money damages. So those are serious things and unacceptable, but landlords do it with some frequency. Okay. In Iowa, the grounds for eviction are basically 4 if you're a tenant. There's a couple others, but most relevant to sort of the standard landlord-tenant relationship are for non-payment of rent, holdover. Holdover is a situation where the tenancy is ended for some reason. Maybe it's the end of the tenancy or because of some other violation, the tenancy is ended, but the tenant is still in the property. Lease violations, and clear and present danger. So those are the reasons that landlords can evict in Iowa. Otherwise, you cannot remove a tenant in the middle of their tenancy or the middle of their term for tenancy unless there is a violation. And in order to remove someone, in any case, a proper notice is required. So in the case of non-payment of rent, you need a 3-day notice to cure, meaning the tenant is going to have 3 days to pay the rent. And if they don't, then the tenancy will end, and then the landlord can file an eviction, and then there will be a hearing and then a court order. Many steps have to happen for that to happen, and if the tenant cures or pays the rent, nothing more can happen. The same with a 7-day cure for a lease violation. The tenant has to be given 7 days to fix whatever they are violating. However, if in a 6-month period, the tenant violates or does something substantially the same as that first violation, then they do not get that opportunity to cure, and they can be evicted with a simple just sort of notice saying you're going to be evicted and then a filing. Another one is a 3-day notice to quit for clear and present danger. This is frequently misused, at least from my perspective. During the moratorium, we saw someone who filed a 3-day notice to quit for clear and present danger for non-payment of rent, which is clearly not a clear and present danger. A clear and present danger is supposed to be something that seriously impacts the health or safety of other tenants or the landlord. There's specific protections in that law for domestic abuse because historically women or men that were being evicted, the victims of domestic violence were evicted because of their abuser's acts. But a person does usually have to take some sort of action which is required to be put in the notice, something like reporting the violence to the police, writing a letter saying don't come back, or getting a protective order to protect themselves under there. And this requirement, there's no opportunity to cure or fix the problem, but it does have to lay out very specifically what happened. So frequently we'll see a notice that says something like, they did something that was dangerous, or there was a clear and present danger, but it doesn't say what the thing is. And it has to say what the thing is, because how can you defend against that thing if you don't know what it is? The other notices to know about are a 30-day notice to terminate. So in Iowa, frequently we see 1-year leases. That's maybe the most common. And then we also see month-to-month leases. And at the end of a year lease, if you don't sign a new lease, and unless your lease very specifically says it's going to renew for a longer period, by law, it automatically turns into a month-to-month lease. And with a month-to-month lease in Iowa, you can terminate with a 30-day notice for no reason at all. So during the lease term, you have to have a reason, a violation. But in a month-to-month lease, you can just say, I don't like you anymore. Here's a 30-day notice, which obviously it can cause issues. It can be a reason. There's always a reason, right? No one does it for no good reason at all. And during the pandemic, what we've seen is that being used to get around some of the protections that otherwise exist for tenants. And finally, there is a 3-day notice to quit. That has to be served after the end of a 30-day notice. So if you're getting evicted from a month-to-month tenancy, you have to have a 30-day notice to terminate 30 days prior to the rent being due. So it can't just be, it's February 4th and I've decided that on March 4th you're out. It has to be 30 days prior to rent being due. And actually February and March is an interesting one because February is a short month, and so landlords frequently mess that one up. But so if your rent's due on March 1st, then it has to be 30 full days before March 1st. And then if the tenant still hasn't moved out, they're entitled to another notice called a 3-day notice to quit. And then the landlord can file for eviction. The 3-day notice to quit can also be used in situations where the tenant actually has no tenancy, commonly referred to as squatting. Okay. All of these notices and the court filings that follow must be properly served. There are 3 ways to properly serve a notice under the landlord-tenant laws. So the first is personal service. That means a sheriff, a process server is coming and actually handing it to an adult in the house that lives at the house, right? So cousin Tom, who's 15, that's not going to cut it. It's got to be an adult living there. It also can't, the person serving it can't be the landlord or anyone that works for the landlord. That's not considered personal service. If the landlord wants to hand the notice over, then the tenant has to sign. And usually I advise my clients, don't sign, because you might buy yourself a little more time to, if it's a non-payment of rent, if they have to go and actually properly serve it, it's going to take a little more time, and it's all the more time for you to get your rent together. So generally, I just say don't sign anything your landlord brings. Your attorney told you so. And the other and perhaps most common way to serve notices are by certified mail, regular mail, and posting. A landlord has to do all 3 of those for it to be considered service. And if the landlord chooses to serve that way, 4 extra days are added on. So if it's a 3-day notice for non-payment of rent, they have to post, put it in the regular mail, and put it in certified mail. And the day that they do all of those things, then you get 4 days until you're considered served. And then once you're served, then your 3 days to cure period runs out. And as you might imagine, that's where a lot of trouble comes and a lot of confusion comes. Probably a good time to check in with a landlord or with a lawyer if you've received any of these notices, but certainly for some of those really hyper technical issues, a lawyer can be really helpful in understanding rights. One other sort of nuance is that the court filings actually, they can't serve those certified mail, regular mail, and posting unless they've tried to personally serve them twice. Okay, again, a court order is required to evict. And so here's some pointers here. Do not move because the landlord has given a tenant notice. you know, what we know from the research is that many people never show up at their eviction hearing, and that could be for all sorts of reasons, but there's a good chunk of those people that get a notice from their landlord, get scared, and move out before they raise any rights. Maybe they even have lots of rights. Maybe they even know this is retaliation, but they figure the system's stacked against them. They don't have a lawyer, and they're just going to get out. But a lot of people think, oh my God, I have to get out and I have nowhere to go. And that is not the case. The notice doesn't do anything. It can't make you get out. No one's going to show up at your door and force you out. It's a notice sort of raising that you should be aware that you might have to take some action here. Like I said, if a tenant gets a notice, it's a good time to call a lawyer, because there are certain circumstances where a lawyer might say, gee, this isn't looking so good. Probably your landlord is going to be able to get you out. It might be a good idea, if you can, to get out so that you don't have an eviction on your record, because that's going to make it that much harder for you to find a new place. So there are going to be circumstances where it makes sense to move out, but often tenants do have defenses, and just simply getting the notice is not a reason to get out. Landlords are known to serve notices just in hopes that they can get someone out without having to go through the court process. And absolutely do not move because a landlord calls, texts, or emails. Nothing can happen. I mean, of course, people can act illegally, but they're not going to get a legal eviction order from a court if they haven't sent those proper notices, if they haven't served them in the proper way, and no proper way involves calling, texts, or emails. If a landlord or if a tenant is at home, has either been locked out, they went out to the grocery store and get home and the lock has changed, or their landlord's there just trying to take stuff out of their house. These things do happen. They should call the county sheriff. The county sheriff knows this and usually is quite reliable in saying, you need to put the lock back, you need to leave these things alone, you need to go get a court order. Usually that is the number one first call a tenant should make if that happens, and also probably a lawyer, especially because, like I said before, damages are potential if the landlord is acting illegally. Another important point is to go to the court hearing. A huge majority of people do not actually show up for their eviction hearings. And the numbers are not in their favor, right? Most people that have a court hearing do get evicted. But we think that in part that's because they don't show up. We've done a lot of data, reviewing all the data from the evictions since the beginning of the pandemic. And what we see is that we know our judges know certain defenses, but they don't care if the tenant doesn't show up. But if the tenant does show up, the judge is more likely to go through all the requirements. And the requirements for an eviction are actually very strict. It's very easy to evict someone in Iowa. It's very quick. Once you file, you are entitled to a hearing within 8 days. So the process is very quick. But in exchange, the court requires you to meet your obligations as a landlord very strictly. But if the tenant's not there, the judge usually just sort of goes through some very basic motions and doesn't look carefully, as they might if the tenant is there. Something that's important, perhaps for you guys especially, is an interpreter is required. If the court cannot get someone either on the line or in person that day, they have to continue that. Until they're able to get an interpreter in the proper language, and that interpreter has to be paid for by the court. And then finally, even if the judge evicts, it's important to know that the tenant will likely have at least a few days to move. The way the eviction works is that the judge says in their order, a writ is going to issue. A writ is the magical document that changes the possession and allows the sheriff to show up at someone's house and take their things out of it. Usually the judge will say the writ's going to issue immediately, in a day, or within a few days. It sort of depends by county how judges usually do it. And then at that point, the landlord actually has to request the writ from the court and get the writ over to the sheriff, and then the sheriff has to act on it. When I was practicing in Lynn County, we usually told people that it would be about probably a week before the Lynn County Sheriff would actually arrive. And usually they would post a 2-day courtesy notice on the tenant's door, letting them know that they were planning to come in 2 days. If a tenant is evicted, it's a really good idea to call down to the county sheriff and ask what their normal practice is. It just gives the tenant an opportunity to get their most important documents and possessions out and have a sense when this is going to happen. And I didn't have a good place to fit this in the presentation, but another thing just to note is as far as deposit goes, a landlord has 30 days to return the deposit or provide an itemized list of where the deposit was used. So if the landlord just does nothing for 30 days, even if the tenant just utterly destroyed the place, they're still required to give back the entire amount of the deposit unless they've given that itemized list. Okay, so as I mentioned, there are lots of, and I'm going to check my time here. There are lots of protections that a tenant has. And one of them right now, a big one, is the CDC eviction moratorium. Many of you have probably heard about this. It ends at midnight on December 31st, except of course, it wasn't really put in place like most laws are because it was an emergency. And so it could be changed by Congress, by court order, or by the CDC itself. So we hope it's till at least December 31st. It could be later, it could be sooner. And what it does while it's in place is it prohibits a landlord from evicting a tenant if the tenant provides the landlord with a declaration similar to the sample provided in the CDC order, which I'll talk about. And this applies to non-payment cases. I guess I do say that here in a minute, but one of the most important things is that each adult tenant or resident must complete their own declaration and give it to their landlord. That's something that we've definitely seen the larger landlord companies push back on in Polk County. And a tenant can give it to their landlord in any way. If you text back and forth with your landlord all day long, you can give it via text, you can give it via email, you can put it in their Dropbox, you can hand it to them. But you do want to have evidence that you did that, especially if it heads to court. So if the only way you work with your landlord is you drop your rent in a box every month, you might want to have a witness go with you or videotape yourself on your phone, dropping that declaration into the box so that you can show to the judge that your landlord really did get it. Like I said, this applies to non-payment of rent cases, but it's really important to be careful here because many landlords will, on the document saying, why are you being evicted, the basis for the eviction, they'll put holdover. And that's because technically under the law, what happens when that 3-day notice is the lease terminates, and then at that point, the tenant is holding over. So often they'll put non-payment, but they'll also often put holdover, and holdover could be rent related. Also, we know that many landlords try to get around some of these protections, so they might file for a different way. And if that's the case, it makes sense to complete the CDC declaration and tell the judge, this is really about rent, especially if a tenant is behind on rent. That's good evidence that this is probably really about rent. This applies to landlord-tenant cases, so the classic landlord-tenant relationship, including manufactured housing or mobile homes, and real estate contracts. It might also apply to some other kinds, although that's less so the case with recent guidance from the Supreme Court, and you'd want to talk to a lawyer if any of those others might apply to your tenant. And basically, because the CDC order says it is illegal for a landlord to do anything that would cause the removal of a tenant if they've received the CDC declaration, that means that even if an eviction has already been filed, or even if an eviction has already been ordered, the CDC declaration will either stop the eviction or stop the actual order from being executed, stop the sheriff from coming out. And the Supreme Court's guidance from earlier this month makes that even clearer. Many of you have probably at this point seen the CDC declaration, but these are the things that it needs to say. Tenant has made their best efforts to get available government rent assistance. what best efforts is a great question that hopefully we're never going to have to litigate. We haven't really seen a lot of that across the state. But obviously, you know, encouraging tenants to call as many people as they can, at least government resources. There's the requirements for the tenants, who's almost everyone is going to meet if they're facing eviction. So 99,000 in 2020, not have been required to report in 2019 or have received a 2020 stimulus payment. Any of those will qualify a tenant. The tenant must be unable to pay the full amount of rent due to substantial loss of household income, or also out-of-pocket medical expenses that are more than 7.5% of the tenant's income. This is one, it's important to note that many of the rent assistance programs required the loss of income to be, quote, COVID related and after a certain date in the spring. This doesn't have any of those strings, so it's much broader. And the CDC order specifically said it's intended to apply very, very broadly. So we've been arguing it in a lot of circumstances, because the point is to protect not only tenants, but for everyone, because we know people moving out and being evicted is going to cause further community spread of a deadly virus. And so that's the purpose of it. It needs to be interpreted broadly. I've got a question here. Yes, undocumented tenants. I actually reviewed it again today. There's no mention of anything about documented or undocumented, and I don't think that anyone would be inquiring into that. A covered tenant is simply defined as a person who lives in a place that is given their landlord or someone else who has a right to evict them that CDC declaration. Other things, the tenant, oh, sorry, I got another chat. Oh, welcome. Tenant must be using their best efforts to make timely partial payments that are as close to the full payment as the individual's circumstance may permit, taking into account their other expenses. The important thing to note here is that as close to full payment could be zero for some people, and they can still truthfully sign it. If you've got just enough to feed yourself and your kids, you can't pay rent, and that's as good as you can get, you can sign this declaration. I think they were just trying to get at the point that people shouldn't be trying to hold on to money and save it for a rainy day in this scenario, and they really should be trying to pay what they can to their landlord. And finally, the fifth requirement is that the eviction would make a person homeless, and that includes if they have to move into another family in close quarters, which I think most people are going to qualify on that point. Just a couple of quick tools for you. There are some online tools to complete the declaration, and you can actually, a tenant can sign on their computer, tablet, or phone. That's been really useful for a lot of our clients who don't have a printer but can text or email from their phone. And I went through the process myself, and it's pretty slick. It also creates this cover letter that sort of tells the landlord, hey, this is what this is, and by the way, you could face fines and jail if you don't abide by this. I think more landlords are aware of it, so that cover letter is maybe less critical now, but there are cover letters out there that could be useful. There's also, the declaration has been translated into many other languages. We have many on our website, although maybe not some of our most critical languages, because I cannot figure out how to get it up there. It's on my list. If there's something you are specifically searching for, please don't hesitate to reach out to me, because I might have it or have access to it, and I just haven't figured out how to get it onto our website. Our website is iowalegalAid.org, and we've got the declarations, more information about the CDC order, and links to that online tool all on our website. One of the important takeaways about the CDC declaration, though, is that rent is still due. And what we don't want people to do is sign this and be like, great, I'm safe, and then I'm going to deal with this on January 1st. Now is the time to be taking advantage. The CARES Act pumped quite a lot of money into rent assistance across the state, and we expect that some more money will be coming online. Some of that money does have citizenship requirements with it, but some of it doesn't. So it's really worth tenants trying to reach out and finding out what is available. If a tenant is facing eviction and their landlord even accepts some rent, that may be enough to protect their tenancy. So it is worth trying to pay what they can to their landlord. To find out about rent assistance that's available, it's really complicated right now because there's so many federal grants going into so many organizations. But generally, I found that if you can find one organization, they're going to know about the others that have money. So a good place to start is United Way's 211 number or a website called houseiowa.org. You can go there and click on different counties in the state and get to some of their rental assistance people. I also just had one of our AmeriCorps make like a master list, which I would be happy to share with you once I check it over. And then finally, just a final point here is that many barriers to income are actually legal problems. Evictions are usually not actually the problem. They're a symptom of a deeper problem. And those problems might be an inability to get access to unemployment, public benefits, disability benefits, child support, or maybe those poor housing conditions are costing the tenant a lot because they have to turn the oven and then pay for the massive electricity bill that comes with it. And those are all good reasons to talk to a lawyer. And again, that's our number and our website. And I can also in the chat, let's see, I can put my email in the chat too, if that's helpful for people. Right, sorry, that took me, I thought I was going to get through a little bit quicker, but if anyone has questions, I'm happy to stick around.
Yeah, you're totally fine. That's basically the last thing I was going to say is if anyone has any quick questions they want to drop in the chat that they haven't already asked, or anything, we have a few more minutes. So I think like maybe 2 short questions, 2 or 3.
And I'm also happy to like speak to a real human if anyone wants to put their mic on or follow up with you.
I would just give it a second. Maybe they're typing it out right now or something.
Okay. So nothing. I'll just assume I did a really excellent job.
Yeah,
Got you all the information you could ever need.
Yeah, thank you so much for this presentation. Like with respect to your time, I guess you're 3 minutes, 3 minutes before schedule. But yes, to answer some of the questions of this PowerPoint will be available on Rossi's website under Refugee Summit and on our calendar. It'll be available for future viewing to share to your clients, which is really what we hope to do. The more people who see this, the better. This is just an amazing presentation. Like you exceeded all expectations, Ericka. So thank you so much. But
actually,
yeah,
sorry. The one other thing I was gonna say for clients is we have tons of information on our Pretty Hideous website, and for that we apologize. It's a little bit out of our control, but we also have, it's a little bit different these days. We used to be able to walk into our offices and grab our landlord tenant booklet. But I think there's still availability to request those online for any tenants that might be interested in them. They can be super helpful.
Perfect. Yeah, so Ericka put her email in the chat. If you need that, you can go ahead and feel free to contact her. But with that, I say thank you so much, Ericka. Yeah, please reach out to iowalegal.org as well as the Refugee Alliance Central Iowa for any more information. But thank you all for your time. Thank you for coming, and thanks again, Ericka.
Yep, have a good one.
You too, bye.